All right, good afternoon, everyone, and welcome to our June in the Boardroom titled County and Municipal Borrowing Basics. My name is Sarah Diedrich. I'm the Director of Outreach and Member Engagement at the Wisconsin Counties Association, and I am proud to serve as your host for the In the Boardroom series. Before we get started, I just have a couple of quick announcements for everybody. First, if you have questions during the webinar, please feel free to use either the chat or the Q&A feature found in Zoom, located on the bottom of your screen. We will be monitoring both the chat and the Q&A throughout the webinar. And as questions pop in, we will try to answer them. If we don't get to your question right away, please know that we will get to all of the questions by the end of the webinar. The second thing I want to mention very briefly before I turn it over to our speakers today is this webinar is being recorded, and will also post that recording on the WCA website along with the PowerPoint presentation from today's webinar. So again, with that, I think that is everything I have. So at this time, I'm going to turn it over to our friends from Attolles Law, of which this series is named, Andy Phillips, who is, the star of the In the Boardroom series.
All right, that's good.
And
That's
we
good,
have Ben
Sarah.
Connard. Ben, I think this is the first time you are joining us, and it is your job today. We're bringing in the big guns today so that Ben can make sure that Andy behaves, that Andy stays on task, and that he makes Andy look good in the event, Andy maybe said
That's
something he shouldn't.
that's no small job. That's no small job. It's a good point, Ben. Thank you for joining us today. This is an in the boardroom discussion, not so much a webinar. So if you have questions as we go through the discussion today, feel free to drop them into chat or Q&A. We'll get to them as quickly as we can. This is a topic we haven't addressed before in the boardroom, or frankly, I can't remember addressing this topic in any great detail in any sort of webinar or in-person type setting. It's a question, it's issues that we confront with our public finance team. Ben is the head of our public finance team here at Attolles, and he's worked with several counties around the state on public finance issues. I've obviously worked with different counties on different finance issues. Ben is far more the expert than I am on these issues, so he's going to do a lot of the talking today. He also controls the slide deck, and so if you see errors or issues with that, it's Ben's issue, not mine. But these are some basics that we want everybody to have an understanding of when you go into this whole question of borrowing. I think everybody has a pretty high level understanding of borrowing, and we want to reinforce some of the fundamental principles associated with the rules surrounding counties borrowing, and then also highlight some of the more intricate portions of the analysis relating to tax implications and things like that. We do all of this not in an effort to bore you. That's not our intent here. Although even Ben and I will admit that this isn't the most exciting topic in the world. We do all of this so that people understand the various considerations that go into the question of whether we should borrow money or how we should otherwise fund some of the projects and obligations that we have as counties. It's titled County and Municipal Borrowing. We're not going to get into the details of school districts, cities, villages, towns borrowing. We're going to focus on counties, but understand that some of the rules surrounding borrowing are the same for counties and municipalities. And so that's why it's titled the way it is. With that, I'll turn it over to my partner, Ben Connard, to start walking us through this analysis and start the discussion. Ben, take it away.
Thanks, Andy. And yeah, the reason, to Andy's point of it being titled County and Municipal Borrowing, is exactly the reason he said. Some of the ways we look to support for what counties are able to do, it does hinge on what other municipalities are able to do, because the rules are somewhat interchangeable, and sometimes we can find authority and examples from things that schools or cities or villages have done that would also apply to counties. So I guess the main overview of what we're going to go over today, the types of county financings, and by that we mean what avenues are most often used by counties for financing projects, or at least avenues that are available to counties for financing projects. So the real four main categories there are going to be general obligation debt, which I think everyone on this call is probably most familiar with. That's going to be your bonds issued by counties to finance a highway project or a county building. And then revenue anticipation notes, we'll get into that. But counties are permitted. I know counties don't do this a ton, but counties are permitted to borrow in anticipation of future revenues that they are entitled to receive. Revenue obligations is something different from general obligation debt. That's for projects that are revenue producing projects. And then conduit revenue bonds, which is going to involve a private borrower for private projects that counties may be asked to participate in sort of a public-private partnership type scenario. And as Andy mentioned, we'll walk through some tax considerations, just high level. And then while not exactly in line with borrowing, we wanted to address levy limits and the process for a referendum to exceed a county's levy limit and some exceptions there, just because it is somewhat intertwined. And we'll show how that is as we go along here. So again, the four main types of county financings we're going to talk about are general obligation debt. So that's the issuance of bonds or notes by a county to finance county projects, usually capital improvement projects or equipment purchases or rentals. And that's all done under Wisconsin statute chapter 67. And there's certain rules implemented in that chapter that are from the Wisconsin Constitution. And then again, revenue anticipation notes, that's a short-term borrowing against anticipated future revenues that the county is entitled to receive. Revenue obligations, bonds, issuance of bonds or notes to finance public utilities. And it has a broad definition. Again, we'll get into this more as we go along. But as an example, for municipalities might finance streetlights that way, parks, hospitals, that sort of thing. And then again, conduit revenue bonds are going to involve private borrowers to finance certain like industrial projects or other exempt facilities or other private activity type projects. And as noted here, those bonds are secured by the revenues of the borrower in the project and not the county. And again, we'll get into this.
Right there, Ben. I mean, we use terminology in public finance that I don't think the rest of the world uses. And so when we say the word conduit, I think you and I have a different idea in our mind of what a conduit is compared to the general population, those not involved in public finance. Conduit is simply the vehicle that is utilized to get a borrower from point A to point B being the tax exempt market. If it's a private activity bond, a private entity doesn't qualify for tax exempt status on the borrowing. In other words, the investor, whoever purchases the bonds, doesn't have the ability to write the interest off from their federal tax return. So the conduit is the vehicle to get to the tax exempt market. In order to be a vehicle, be a conduit, you have to have municipal status. And so oftentimes counties, we've been seeing this more and more as we've seen the proliferation of so-called P3 projects, public-private partnerships. We've seen counties being requested to be the conduit, the conduit issuer on those bonds to allow access to the tax exempt market. So we'll get more into some of the details associated with that, but at least in my experience, I've seen more and more of that over the past, however many years. I think it's going to increase in popularity out there as we're looking at ways to finance economic development in a way that does not impose an obligation on the part of the county, but yet provides a benefit out there to private parties who are looking to lower the cost of capital.
Yep, that's exactly right. Especially in this higher interest rate environment, it's probably going to be more and more common. So getting into some of the details on general obligation debt, as I mentioned, the Wisconsin Constitution places certain limits on counties and other municipalities in terms of the amount that they're able to borrow. So I guess taking a step back, when we say general obligation debt, and we'll get into some more detailed examples on this too, we're talking about debt issued by the county that's a general obligation of the county. It's backed by the full faith and credit of the county, and the county is obligated to pay the debt and doesn't have any way to get out of making that payment. So again, as I said, it's obligation secured by the full faith and credit of the county, and the county is required to implement an irrepealable direct annual tax. So that's a property tax. I'm sure everyone's familiar with that. It goes on the county property tax roll. And then the debt limit established by the Constitution provides that counties may not contract to become indebted in an amount that exceeds 5% of their total equalized value of the taxable property located in the county. Obviously, that can change a little bit from year to year based on the equalized values that GOR puts out. So as long as the county is staying under that limit, they can issue debt. Some other requirements with general obligation debt. Again, that direct annual tax has to be implemented to pay the principal and interest on the debt. And then general obligation bonds or notes cannot have a maturity greater than 20 years. It can be less than 20 years, it just can't be greater than 20 years. And that's a constitutional requirement. These principles have been backed up, I guess I'll say, by the Wisconsin Supreme Court, who has opined that the goal of these debt limits is to impose a burden on those who are voting for the debt and not future generations, and to not become overburdened by debt. So this is ended up, some things with borrowing debt have ended up in front of the court over the years, and the court has affirmed those constitutional principles. So now, like I said, we'll get into a little bit more detail on what counts as debt and what doesn't, and some more court cases, because the statutes, neither the Constitution nor the statutes define what debt is. So it makes our job more fun and keeps me and Andy employed, I guess, because nobody knows what it actually means.
Yes, thank you for that. I think we're very thankful for that, Ben.
Yeah. So the court has defined debt as, this first example is an older case, as all absolute obligations to pay money or its equivalent from funds to be provided, as distinct from money presently available. So again, you're obligated to pay in the future, not right now. And the second test here is the test that the court provides, whether the municipal body, county in this case, is under an obligation to pay, and the creditor, so the bondholders, would have the right to enforce payment against the county or its assets. And then this final example here provides that debt is an obligation backed by the full faith and credit of the municipality, or the county in this case, and is payable from a general property tax revenue secured by property or assets already owned by the county. So again, we're really talking about anything that the county has promised to repay. It's secured by a property tax implemented by the county, and or other property that the county already owns. And
so when we're looking at this, when we're looking at these tests, Ben, I mean, the thing I want to point out too is that just because it's called something different doesn't mean it may not be general obligation debt. I think you have to be careful there. If you look at the last bullet point on this slide, the pre-existing asset doctrine, if you are pledging assets that were in existence prior to the financing you're undertaking, in other words, it's not going to be a purchase money type transaction. For example, you go to buy a car, you're going to finance the car dealer or the seller is going to take a security interest in that car to make sure you pay all of your bills associated with financing that car. If you were to pledge your house, unrelated to the car, as part of that transaction, that's the distinction with the pre-existing asset doctrine, okay? And so when we're looking at this, it's important for determining the appropriate constitutional limitations on the level of indebtedness you can incur as a county by looking at the totality of geo debt that may be out there.
That's right. And that pre-existing asset doctrine is important later on when we talk about revenue obligations as well. So some examples, before we get into the examples, what doesn't count as debt? So really the converse, any obligation that is not a general obligation of the county, entitling creditors to look to the county's revenue for payment, is not secured by an asset already owned by the county. So any financing scheme, this is an important case, any financing scheme where the county may avoid its obligation if there's conditions precedent that exist before the obligation must be repaid. So in other words, if the county has some way of getting out of paying the debt, it's not a general obligation debt. An example, and it's going to be on the next slide, but I'll talk about it now before we get there, is, let's say the county enters into a lease purchase or a lease to own type arrangement for some equipment, but the lease contains a non-appropriations clause. So the county can always get out of the next lease payment by not appropriating funds. That would not be considered general obligation debt.
Yeah, and let me just make a point about that too, Ben, and maybe you can go to the next slide as we talk about this concept, is that an appropriations clause is going to give the county the ability to stop the entire financing mechanism. It might have to give up the particular property that is being financed through that mechanism, but at least it's not on the back of all of the taxpayers in the county in terms of being a general obligation. And that may seem like a good idea. We're limiting our exposure as a county. Beyond the legal issues, there are very practical issues at play here, because you might imagine that a county that walks away from its debt obligations might not be viewed favorably in the marketplace. And so there's a general acceptance in the public finance world that more times than not, overwhelmingly more times than not, municipal entities are going to follow through on their debt obligations, even if there is an appropriations clause, because they don't want to suffer the consequences of a bad credit rating or having a reputation of walking away from their debt. All right. So again, we get into the legalities here, and bond counsel, issuer counsel, the lawyers that represent you as a county are going to look at those legal issues, but they're also going to have discussions about some of the practical implications associated with those legal issues.
Yeah, and that's again to Andy or to your point. It's not to say it's a good idea to not exercise that option. It's just if the option is there, and it might make sense to build in just for the fact of making sure it's not general obligation debt for one reason or another. So some other examples: any loan secured by special assessments and not general property taxes or other general assets of the county. Revenue obligations, which we're going to talk about more in a little bit. Revenue obligations are typically only secured by the new property that's being acquired or constructed. And then, as I mentioned, the lease purchase arrangements, and then bond or revenue anticipation notes also are not considered general obligation debt. Authority to borrow is important. So that general authority, individual municipalities and counties may issue general obligations or notes to finance any project that's undertaken for a public purpose. And those requirements are set forth again in Chapter 67 of the Wisconsin statutes and the Wisconsin Constitution. Public purpose is, again, pretty generally defined. It's the performance of any power or duty of the issuing municipality. So for counties, any statutory duty that the county is required to undertake is something that would be a public purpose. Like the county has to have a courthouse, so that building a courthouse with money obtained through general obligation debt would satisfy the public purpose requirement. And a project, again, is pretty broadly defined, but we're really talking about capital improvement projects like building a new building, building a new highway, acquiring land. And as mentioned, equipment is included in there too. So think of fleet vehicles for a county. If the county were to purchase the vehicles, they could issue debt to purchase the vehicles.
So let me just back up for a second, Ben, and talk about the public purpose doctrine for a moment, because that has constitutional implications beyond the statutory definition. The public purpose doctrine is not explicitly in the Wisconsin Constitution, but it's baked into the Constitution. What I mean by that is that over time, our Supreme Court has interpreted that doctrine to impose a requirement upon governmental entities to exercise their powers in the interests of the governmental entity. That's the public purpose doctrine in a nutshell. Now, recently, it has been interpreted very expansively, very broadly. And more times than not, courts are going to find that there is a public purpose. However, as it relates to counties, this is a consideration. Remember, as counties, we can exercise only those powers granted to us as counties by the legislature. We do not have constitutional home rule authority like cities or villages do. And so the public purpose doctrine analysis for us as counties is going to be a bit different. So I just want everybody to be aware of that beyond the statutory definition of public purpose, we also have the constitutional implications. And by the way, those constitutional implications extend far beyond just debt issuance questions. They extend to every aspect of what we do as counties. The other thing I want to point out is as it relates to the definition of project, that's very important because Ben's about to talk about this whole concept of levy limits and how debt issuance impacts the levy limit calculation. And so when we look at the definition of project, you're not going to see the word operations anywhere in that definition. That's important because I often get asked the question about how do we borrow money for purposes of funding our operational challenges and operational expenses associated with county government. And that's a much different and more difficult analysis because as it relates to the authority to borrow, we can only borrow for a project which does not include operations.
Great. Yeah, counties are prohibited from borrowing for operations costs in most cases. That's exactly right, Andy. So again, some examples, and we already walked through some of these with capital improvements, government buildings, public utilities, other property. So for counties, county courthouse, administrative building, highways, a county jail, anything like that fits in that bucket. And right to Andy's point, the note right here, counties generally may not issue debt to finance operating expenses or general fund expenses of the county.
Well, and I think that highlights the need to have a comprehensive strategy as it relates to your borrowing. What I mean by that is that, again, as Ben will talk about in a bit, we have a levy limit calculation which says we can only issue this amount of tax out to support our budget. And we have a levy limit. We can't levy more than our cap. However, debt service is excluded from that cap. And so we have to be strategic about what we're going to borrow for and what we're going to pay as we go for. Pay as we go is based on tax levy contribution. That's it. But with debt service, we get that levy relief. And so we may want to look at opportunity to push certain expenses that we've historically paid as we go, push it over into debt service because we get levy relief. Again, it's going to be unique circumstances for each county as to that decision. But again, if we're strategic about it and we have a plan in place, it makes it a lot easier.
That's right. Specific to counties, and this is specific to counties and not other municipalities. In order for a county to issue bonds or promissory notes under Chapter 67, so this is for GO debt, the county must satisfy one of these 6 requirements, any one of the 6, not all. So one option is for a county. So let's say a county wants to build a new courthouse, and it's wants to issue bonds to finance that. The county could decide to hold a referendum. So very similar to what everyone's probably very familiar with like a school referendum to build a new school. It would be a vote put to the voters of the county to decide whether the county should issue that debt. If the county board adopts a resolution setting forth its reasonable expectation that the anticipated debt issue will not require the county to increase its debt levy rate. Probably not going to be the case if you're building a new county courthouse and financing that. 3 is talking about some very specific instances that we don't need to get into now and are almost certainly things that aren't ever going to come up. Number 4 is debt to issue to fund or refund outstanding bonds or notes. Obviously, building a new courthouse, you're not refunding debt, you're issuing new debt. But I guess while we're on that point, if the county did have outstanding debt that it wanted to refund, it's able to do that without going to referendum or having to meet any of these other requirements. Reasons for doing that might be that the county might have outstanding debt that it wants to, if it has the ability to reamortize that debt over a few more years. If it has the ability to do that, to reduce payments, or maybe they're able to get a lower interest rate than what they issued the debt at to save on debt service down the road.
Stop you there quick, because I don't know if you're going to get into it, but I mean, an example of how the federal rules surrounding taxation of the interest on these bonds come into play here, because with the Trump tax reform that happened back in 2017, I think it was. They took away the ability to conduct advance refundings. And advance refundings is simply saying that if you have debt that's outstanding that has a no-call provision, in other words, you don't have the ability to refinance that debt for a certain period of time. Let's say it's 5 years. And in year 3, you take a look and you say, interest rates have dropped 2 points. I really want to refinance because I can achieve the savings associated with that spread on the interest rate if I could just refinance now, but I got a 5-year no-call provision in my debt. And so under the prior to the Trump Tax Act, prior to that, you could simply place the money in escrow and then have the escrow agent pay out upon the term period as provided. So you could take advantage of the lower interest rates. That was called advanced refunding, and I'm oversimplifying this entire process, but that's advanced refunding. That was taken away, all right? And so we don't have the ability to conduct advanced refundings anymore. That said, we still have the ability under Wisconsin law to reissue, refund outstanding notes or bonds. And so if we have the opportunity to conduct that type of refunding reissue, we ought to take a look at that in order to lower interest rates, as Ben stated, extend maturity, or other reasons we might want to refund on our existing obligations.
Yep, and that would be a current refunding. So if you'd have to look at the terms of your outstanding bonds to see when you're able to, as Andy said, call the bonds and refund them, basically outside the lockout period. And then so the fifth option here is probably the most common that I see when it comes to county borrowing, and you can correct me if that's not the case for you. Yeah, but if the county board adopts a resolution to issue the debt by a 3/4 vote of the members elect, then the county doesn't have to do any of these other things, including going to referendum in most cases. So that's overwhelmingly the most popular option of the 6 here, and the 6 is again limited to debt that's issued for the purpose of installing energy efficient equipment. So really, to go back to my initial example here of building a new courthouse, really your only options are 1 and 5. You either get a 3/4 vote from the county board, or go to referendum.
The only thing I'll note on that, Ben, is that it's the full county board. It's not just a quorum. It's not 3/4 of the quorum, 3/4 of the people that are present.
Right.
It's 3/4 of the entire county board. Now, you don't count vacant seats. Okay, I get that. But everybody who's entitled to have their seat in a chair, that's counted in that 3/4 requirement.
Right. As mentioned,
Real quick, Ben, before we move on, we did have a question from Jason here. Do we have any experience with counties using option 2? Why don't we go back to the previous slide? Governing body of the county adopts a resolution that sets forth its reasonable expectations. The issuance of the debt will not cause the county to increase the debt levy rate as defined in 59605 sub 1B. I've not dealt with that situation. That's going to be a calculation that you have to perform, and you have to be very careful about that calculation. Again, you should have a separate levy associated with GO debt, and so it should be calculable, so to speak. I've not done that, Ben. Have you seen that done before?
I haven't. I think it'd be an extremely rare scenario where you'd be able to implement that. And it'd have to be for a pretty small amount of money, I would think.
Yeah, I think that's right. I can't see where that might occur if you've got some debt service coming off levy, new debt service proposed, new debt service. The increase on top of the levy limit for the debt service is not going to be more than the old debt that's coming off. So you may want to look at something like that. But again, I think you have to be very careful about that calculation, and DOR is going to pay attention to that when it comes to the levy limit calculation.
Yeah, I think in most cases it's going to cause far more headaches than trying to go through one of these other avenues.
Kelly asked another good question, Ben. She says, is installing a solar system, does that meet the requirement for 6? The requirement for 6 is really geared at what statute has it been? 66.0137 on energy efficiency. Is that it? Or is it?
It sounds right, but I don't remember exactly, but that sounds right.
Those are that's the statute that authorizes energy efficiency contracts. And so that's what number 6 is getting at, is that you don't need to go through that process of getting a 3/4 vote or the other conditions there in order to enter into that energy efficiency contract, and you can issue debt to support that contract. All right. That's because there are different rules surrounding those types of energy efficiency contracts. Those contracts were very popular in school districts because school districts were able to get relief from their revenue limit calculations for purposes of those contracts. Back in, I think it was 2016, that was taken away in the budget process, school districts' ability to get relief from their revenue limits. And so those contracts fell out of favor. There may be reason that counties want to do those contracts. One of the primary reasons is you get an energy savings guarantee from a professional certifying the energy savings associated with it. And that certification has to say that the money you're going to save over the long term is going to exceed the amount that you're spending on that contract. So county may want to look at that. But the question, Kelly, about would a solar system meet that requirement? It depends on whether it would be a qualified contract under the energy efficiency statute.
Right. As we've mentioned, the Constitution and the statutes require for general obligation debt, the county to levy a direct annual irrepealable tax. And what that really means is there's a county implements a property tax that's sufficient to pay the debt service on the bonds, so the principal and interest every year. And a future county board cannot repeal that tax. So as long as that debt is outstanding, that tax is there. And the reason for that, well, again, it's required by the Constitution and the statutes. But because it's a general obligation in the county or other municipality wouldn't have any ability to get out of paying that obligation, there needs to be money there to pay it. And frankly, from a bond marketing standpoint, that's a great thing anyway, because it helps the county get a better rate and not have to necessarily put up other collateral to secure payment on the bonds either. So, as far as a bond marketing and pricing standpoint, it's very beneficial anyway. It's levied by resolution, recorded resolution of the county board, and recorded in the tax roll. If there is any surplus money in the debt service fund, so if there's any project funds, and this gets into tax analysis, so I'm going to really oversimplify it here. There might be some money sitting in a project fund or some other fund for a couple of years that earns some interest while it's sitting there that becomes money of the county. That could reduce the amount of the money that needs to be raised by property tax in a given year. So it could end up being lower from year to year or different from year to year, depending on if there's any investment proceeds available to the county, which frankly probably wasn't much of reality in the last 15 or so years, but is again now with the higher interest rate environment that we have. And we'll talk a little bit about that when we get into the tax considerations. But there's a lot of detail and analysis that goes into that. And then this last point is for the first year of the debt issuance, the county might have an interest payment that it's paying in year one, or I guess let's say in 2024 here, a county issues bonds in September, and there's an interest payment due in December, but obviously that tax levy wasn't on in the tax roll for this year, so there's no property tax money available from a specific tax to pay the interest payment. So the county might set aside extra money it had or ahead of time to make that payment, just for the first payment. So moving on from general obligation debt, another avenue available to counties are revenue anticipation notes. So as mentioned, this is a short-term note issued against anticipated future revenues by county. So this could be federal or state aids or property tax or other payments that have been deferred to a future date. Caveat is that the notes must be issued in the same fiscal year that the county is entitled to receive the payment. So you couldn't issue revenue anticipation notes in 2024 for state aid payments expected to be received in 2025. There's a cap that the notes or the bonds may not exceed 60% of the anticipated revenues. It's just a safety net in case that full amount isn't realized, so that there's enough money there to pay off the notes that were issued. And obviously, there's also going to be interest that accrues during that time too that needs to be paid off. So there's going to be a little bit more than the principal that's issued that needs to be paid. And then there's a maturity limit of 18 months. So the notes must be repaid within 18 months of being issued.
Yeah, revenue anticipation notes, again, they're very popular in school districts just because of the way on the calendar the state aid payments come in for school districts. And so they always engage in what are called trans notes, tax revenue anticipation notes. They issue those toward the summer, late part of the summer, early fall every year because the state aid payments haven't yet hit. They aren't as common in counties. The last large scale example I can remember, not to say counties don't run into cash flow issues and borrow temporarily for this purpose, but the last big one I can remember happening were revenue anticipation notes on pension obligations. That was back in the early 90s, if I recall. We went through this analysis about 4 years ago when COVID hit, and we were concerned about property tax receipts not coming in as scheduled, or at least there being a significant drop in those receipts. And so we put together a program for counties to borrow short-term on revenue anticipation notes to fund obligations while we're waiting for those tax revenues to come in. Fortunately, we never had to go there. We did relatively well during that process in terms of tax collection. So revenue anticipation notes are out there. Again, they're prevalent in school districts. They're not so prevalent with counties.
Right. Quickly, benefits of revenue anticipation notes, if you're ever to utilize them, is that there's no tax levy required, as we talked about. It's not considered general obligation debt, so you don't have to go through some of the hoops, like getting a 3/4 member vote of the county board, that or go to referendum or whatever of those 6 options. Revenue obligations. So these are going to be bonds or notes issued by the county to finance public utilities. And by public utility, that's not limited to, what we normally think of as utilities like a power plant or water treatment plant. It's pretty broadly defined to mean any revenue producing facility or enterprise owned by a municipality, including counties, and operated for a public purpose. So examples, streetlights, sewer systems, parks, hospitals, I guess golf courses could fit in there too. Most counties, maybe all counties in the state of India have golf courses.
I don't know if everyone does, but I think that's a great example, Ben, as golf courses would fit here. But when you get through with this, I want to talk to you a little bit about these revenue obligations and how they may not seem as awesome as they first appear.
Yeah. So again, these are not general obligation debt because instead they are pledged by the revenues derived from the public utility. So let's say a county hospital, the revenue that the hospital generates would be the security to pay the debt on the bonds. It wouldn't be there wouldn't be any other money of the county pledged or issued as or used as security to make those bond payments. So there's less risk to other funds of the county. Again, to Andy's point earlier, just because the county doesn't have an obligation to use any other funds doesn't mean the county wouldn't want to do so if the revenues were not sufficient to make a debt payment, because there could be broader implications and issues for the county for not doing that.
But that brings up a good point, Ben, because ultimately the risk is minimal because we're not pledging the full faith and credit of the county to back the obligation. It's only backed by the revenue that's produced through operation of this quote unquote public utility. So if it's a golf course, the greens fees are going to support the revenue obligation. Get it. What's cool about these is that they can be extended out 40 years, whereas general
Yep.
obligation is 20 years. So you get an extended maturity, which allows you to lower the principal and interest payments. That said, you also have to consider the practical terms here, and that is, how is the marketplace going to react to a revenue obligation? What interest rate is the marketplace going to give you on a revenue obligation as opposed to general obligation? I mean, when you think about general obligation, that's a pretty secure investment, because there is never ever in the history of this state been a county that's gone bankrupt. In fact, we're prohibited from going bankrupt. And so a general obligation bond is going to have a much lower interest rate than a revenue bond. So what you see at times is you see a revenue obligation that is backed by a GO guarantee. And so then you get into the complicated questions. Does the GO pledge, that guarantee, does that constitute general obligation debt for purposes of the constitutional limitation, and so on? And so again, not to overwhelm anybody with this, but just understand that there are a lot of moving parts and pieces, which tells us we ought to have a good strategy when we're borrowing money to make sure we fully understand the implications.
Yeah, lots of considerations to take into account. But to your point, a benefit here again is the 40-year ability to go up to a 40-year maturity over 20 is definitely helpful too. So yeah, it benefits to the revenue obligations. No tax levy is required. The debt service is only paid from the revenues. It's not secured by any other assets of the county. Now, one thing you might see is a mortgage on the revenue on the public utility itself. So again, a golf course, the county might, as extra security, issue a mortgage, as security, extra security on the golf course. But none of the other assets of the county would be pledged, unlike a regular general obligation bond. And as Andy mentioned, it's not considered general obligation debt. And counties still have the ability to issue refunding bonds to refinance revenue bonds as well.
Let me just pause a second there. Lance from Marathon County asked a good question. Are revenue obligation bonds a permissible form of financing for work done at a solid waste facility? The answer is yes. I mean, the solid waste facility is revenue producing. And so as a separate component unit of the county or municipality, I assume it's operated as an enterprise fund. You could issue debt to support work done from a capital standpoint at that facility and issue revenue obligations to support that work. That said, I think, again, there are some complications because it's going to depend upon the strength of the financials as to what the market is going to say or interest rate is going to be. But yeah, a solid waste facility under the broad definition of public utility would be eligible for revenue obligation financing here. Do you agree, Ben?
Yeah, completely agree. I guess another point, I guess, with taking into account all these considerations of, should we structure the deal this way as a revenue obligation? Should we structure it as a general obligation? In all these considerations you need to take into account, it's just really hits home the point of having the county having a good municipal advisor or underwriter in conjunction with its own finance team to take into account those considerations. They're going to have a municipal advisor or underwriter is going to have a really good read on the market and what it thinks the county might be able to get for rates, depending on what avenue it chooses to go.
Well, that's a good segue, Ben, to a very brief discussion about the finance team. It's more than simply your county administrator, your finance director, your board chair. It is a team of professionals that are going to look at all of these different traps and opportunities. That includes outside entities like your municipal advisor, who has a singular responsibility to look out for the best interests of the county. Under federal law, they have an obligation. Their licensure depends upon that. And so they are an awesome player to have on that team. And as well, bond counsel or issuer counsel, depending upon the circumstances. The attorneys come in and make sure that we are dotting I's, crossing T's, and doing everything necessary to effectuate the plan of finance that the county wants to pursue. And so it's very important that everybody have an understanding of their role on that team and that the team works together. And so working with a municipal advisor, bond counsel, and others that have familiarity with county government, not only from a finance perspective, but overall operations capital perspective, and understanding what it is the county wants to accomplish is very important.
Yes. Moving on, the last category here is the most different from the other three and doesn't involve the county issuing debt to necessarily to finance its own projects. This is what we talked about earlier with conduit revenue bonds. The county serves as a conduit for money to be loaned to a private borrower, generally tax exempt, to finance certain types of industrial facilities or other exempt facilities. Think, for example, a dock and wharf facility is an exempt facility under the federal income tax laws and has to have involvement from a governmental issuer. That sort of thing. Affordable counties or county created housing authorities can issue bonds for affordable housing projects. I don't think that's probably as common, unless you disagree, Andy, because WIDA and WIFA tend to be involved in those types of projects more than counties, but it is a possibility. Other public improvements or public infrastructure like broadband projects can be financed this way, so basically the county issues tax exempt bonds and the money is loaned to the private borrower who builds the project. And then it's the private borrower that's on the hook to repay the debt service on the bonds, not the county.
So here's a quick question from Mo up in Polk County. County Administrator, can a solid waste facility place a fee on the property tax bill for its operations and be eligible for a revenue obligation? That's a bit of a complicated question because then it becomes a question of the authority for the county to impose a special charge associated with the solid waste operations. If it has that ability, does it have the ability then to impose it to issue revenue obligation notes or bonds in anticipation of those revenues coming through the property tax bill? And I don't know off the top of my head if that would be tax revenue anticipation or a revenue obligation. I'd have to take a closer look at that. My gut tells me that if it's on the property tax bill as a special charge, then it would be a revenue anticipation note, not a revenue obligation that you're discussing here. Ben, do you have any thoughts on that?
Yeah, I'd have to look into that closer, but I think what you're saying sounds like it would be the case.
Okay.
Andy, anything to add on the conduit revenue bond side?
No, other than what I said at the beginning, that we're going to see more and more of this. I think that because we're in an era where government is constrained, especially county government is constrained in its ability to do everything that the state and our citizens expect us to do, we're going to look at opportunities to finance different projects, whether it be economic development or otherwise, in ways that aren't considered rote. What I mean by that is that gone are the days where the only time we issue indebtedness or have any involvement with a plan of finance is general obligation financing. That's going to continue to exist when we build our facilities and stuff. But I think that more and more we're going to see private parties approaching us and saying, hey, what if we do this in a way so that we can borrow money on a tax exempt basis by you county acting as conduit issuer for these bonds, gets us to the tax exempt market, lowers the cost of capital so that we can engage in a project that you all as a county believe is worthwhile, that we ought to do. Because if you don't step in and act as conduit county, we're not going to be able to get this project off the ground. I think we're going to see more and more of that. We've seen that with the proliferation of broadband. Many counties have engaged in discussions with Bug Tussle and either effectuated transactions or are contemplating transactions to allow for the expansion of broadband within the county. As part of that calculation, Bug Tussle is asking counties to step in, be conduit issuer on those transactions to allow Bug Tussle a lower cost of capital. And the question is, what risk is there for the county? That can be a bit complicated because it's the job of issuer counsel, whoever's representing the county, to make sure that there is no risk associated with that type of a transaction. But I think, again, we're going to see more and more of that as we go on.
Yeah. Exactly. And, despite all these benefits that are up on the slide here, no tax levy, there are limited obligations of the county, i.e. they're only payable out of the revenues from the project or the borrower's assets. And they're not, and the bonds aren't a liability of the county. It is still the county's name on the bonds.
Yeah, I think that's a huge reputational risk. Is that who wants paper out there in the marketplace that's gone bad? who wants to default on an obligation? Because regardless of the story we have to tell about it not being an obligation of the county, to the broader populace, they're all going to see a piece of paper that says X county at the top of that piece of paper in default. That's not good. So it reputationally it impacts, and it may have a tangential impact on your credit rating and things of that nature, because credit rating, there are so many different factors that go into credit rating. But again, I think that's why we have to be careful about how these plans are implemented to make sure that we don't have that type of a risk.
Yes, that's exactly right.
Question from Jamie: if the private entity defaults on the conduit revenue bonds, can the county repay the debt through their debt levy? I think it depends from a public purpose standpoint on whether you can commit tax levy resources to repay that debt. Assuming that we can get past the public purpose doctrine, there would be no prohibition on doing that. But I would suggest that you need some sort of really good loan agreement with that private entity, because essentially you're assuming debt that the private entity is supposed to pay. So I think that can get tricky.
Yeah.
Any thoughts?
You'd have to go. Yeah, no, that's right. I mean, you'd have to go through then you'd have to go through the GO, the general obligation bond issuance or debt issuance process that we talked about, because you're making it a general obligation of the county. I mean, you're basically talking about guaranteeing the conduit borrower's debt. So it's possible. I guess there's ways to structure it and ways to do it. It's just you start to run away from the conduit only and no risk to the county to more risk to the county, and still having to go through some of the hoops of the general obligation debt process. Doesn't mean it shouldn't be. That doesn't mean it shouldn't be in certain circumstances. There might be circumstances where that's a good idea. It's just there's a lot of considerations that have to go into that, and whether it's something the county really wants to do.
And I think along those lines too, understand that there are several conduit bond issuers in Wisconsin. Ben mentioned WIFA. The Public Finance Authority is another example of entities that exist for the sole purpose of being a conduit issuer of these bonds. They have a much stronger understanding of all of the rules associated with conduit issuance, and they also have a firm market presence understanding of exactly what it takes to sell these types of bonds. And so I would suggest that there may be good reason that people come to counties and ask for the county to be the conduit issuer. But again, there are resources within the state that if you're asked something strange, reach out to those resources and have discussions about the particulars of any given project.
Okay, we'll very quickly and high level go through some tax considerations here.
If this hasn't been energizing enough, now we're going to talk about federal tax.
Now we're going to talk about tax.
That ought to get everybody super excited right now.
Yeah, especially towards the last 7 minutes of the presentation here. Everyone's wide awake and ready to go. Most county bonds that the county would issue, or even some conduit revenue bonds the county could issue, are done federally tax exempt. So that means the holder of the bond, the investor who owns the bond, doesn't pay income tax on the interest it earns on the bonds. So that's often results in a lower interest rate to the county, because again, the investor is willing to earn a smaller amount on its investment because it doesn't have to pay tax. So it's effectively a subsidy by the federal government to encourage investors to give better rates to local governments or other projects that are financed for a public purpose. Again, this is a federal tax exemption. Generally, this debt is not going to be exempt under Wisconsin law. There's three basic kinds of bonds for tax purposes. So we talked about the types of debt that counties issue or are involved in. For tax purposes, it's a little different. There's general obligation bonds, which we've talked about, secured by the county's full faith and credit and the property tax. Then there's private activity bonds, which is essentially conduit revenue bonds. It's bonds that are financing private activity by a borrower, often a 501c3 nonprofit, but not always. And then municipal revenue bonds, and this is really going to be what you're talking about when we were talking about with the revenue obligations for financing something that's revenue generating, something that's going to generate fees and revenue to pay for the debt service rather than a general obligation bond. So the general requirements for tax exemption, and this is why in a conduit revenue bond setting, the borrower needs a governmental entity, is because a private borrower is not going to meet this test. So the issuer needs to be a political subdivision of a state. Now that is broader than just a county or a city or a village. Under the tax code, that means an entity with traditional police powers, which includes the ability to levy a tax, make and enforce laws, or exercise the power of eminent domain. The bond must be, or note must be validly issued under state law, and it must constitute indebtedness under state law. And for federal tax purposes, that's a different meaning than when we talk about a general obligation debt. Indebtedness under state law for federal income tax purposes means reasonable expectation of payment. So even a conduit revenue bond or a revenue obligation in this case would be considered indebtedness for tax purposes because there is a reasonable expectation that the bonds will be repaid in full. The basic rules that should be aware of are that the county or other borrowing entity can't borrow too much. So you can't borrow more than you need. Too soon is before you need it, or for too long. The reason for this is the federal tax code prohibits governmental entities from exploiting the difference between taxable taxes and interest rates, which is known as arbitrage, which I think we have an example coming up. But basically, arbitrage means if you, the county, borrow money for a project at, let's just use a simple example, 2%, a 2% interest rate, and you don't actually need that money for 2 years. So you let the money sit there for 2 years and invest it in an account that bears interest at 5%. So the county is making a 3% gain basically on that money. But for certain exceptions, you're not allowed to keep that money. You would have to repay it back to the federal government.
You know, Ben, with us running a little bit short on time, I wonder if we don't fast forward a little bit to the levy limit issue. Because that's one of the big issues here that I see counties going through and making a determination on their plans about whether they're going to borrow or they're going to pay as they go.
Sure, let's do that. I think everyone has access to those slides after the presentation. Is that right?
Yep.
Okay, great. We'll skip through the most boring stuff.
Perfect.
All right, everyone knows what levy limits are. So let's skip ahead. So there is a referendum process for counties and other municipalities to exceed their levy limit by going to referendum. Andy, how much detail do you want to get into on this?
Well, I mean, I've seen there have been several counties who have attempted by referendum to exceed their levy limits. I can't recall if anybody was successful on that, but I mean, it's a challenge because the way that they've set it up in 660602 is to make it a very difficult exercise, especially if you look at the required calendar for this referendum question. It's very difficult to try to plan and budget that. It's much easier to try to work with your debt issuance in an effort to take debt service out of that levy limit calculation and work that way than it is to go through the referendum question. I'll just say that.
Yeah, that's true. And I guess, Andy, to your point, what you're saying is if you have a capital project or equipment purchase or something that you could issue debt to pay for, that satisfies the project definition and public purpose aspect that we talked about earlier, it might make sense to do that and free up other current money to pay other operating costs. Is what the point you're making, right?
No, exactly. I mean, for example, a highway project that you might say that highway project is $500,000 and you typically pay as you go using levy. Instead of paying as you go, you might take that $500,000 that you typically spend on highway. You have a specific need in human services, you put that 500 grand to human services and you issue debt to support the highway project for 500 grand. It's an allowable project under Chapter 67. You still have to go through the three-quarter vote process, but you borrow the funds necessary to do that. And then whatever your payments are on the debt service, that's outside the levy cap. Again, a lot more complications than the simple explanation I just provided, but that is something that we need to think about in terms of, frankly, taking advantage of the exceptions that exist.
Yep, and that's in addition to the debt service exception, this slide here just highlights some other examples of things that are exempt from the levy limit increase. So I get the point being, counties should make sure that they're reviewing these exceptions and that they are fitting everything into an exception that they can, again, to free up other general levy to put towards other expenses.
All right, so is that about the end of the slide deck, Ben? Yes, it is. Look at that. So I don't have any pending questions in chat or Q&A, but let me just ask Sarah to turn her camera back on and see if she has any final thoughts, questions, issues, concerns.
I have no concerns. Definitely not. I actually thought this was a great presentation, a great discussion, good questions from folks who have been participating in today's in the boardroom. I learned a lot. This is a topic I don't know much about, so I thought it was really, really well done, Ben. I think you made Andy proud. You made him look good.
That's not easy.
Yeah. So again, I will I'm seeing in the chat, somebody is again asking if we will send out the presentation. We will post the presentation on the WCA website, wicounties.org, under past event materials. And on that page, you will see all of the previous in the boardroom recordings, as well as all of the PowerPoint presentations from the last, I think, year and a half that we have been hosting this series. So with that, I'm not seeing any additional questions from anybody. I just want to make a quick plug though for our July in the boardroom, which is going to be held on July 24th. And that focus of that is going to be renewable energy projects.
A topic of great interest in many counties across the state, Sarah. We've heard all sorts of activity going on out there. So we first introduced that topic, I think it was in February of last year. We're going to revisit it with some of the latest and greatest information that we've got.
All right. I don't see any other questions. So thank you everyone for joining us this month, and we'll see everyone back on July 24th.
Thank you all.
Thank you.